A federal judge has issued a direct command to the United States Marshals Service to step in regarding an issue that directly concerns the current president. This was not a suggestion or a polite proposal. It was a firm order. The Marshals, who serve as the enforcement branch of the federal courts, received instructions to uphold the judiciary's power precisely because officials in the president's administration declined to follow the ruling. President Trump's reaction came swiftly and with great force. He posted a lengthy message in all capital letters on Truth Social, sharply criticizing the judge personally, questioning the integrity of the courts, and challenging the entire justice system. What stands out even more than the content of those posts is the context around them. Members of his legal team and close advisors reportedly made repeated efforts to intervene and stop him from continuing. Some tried to physically remove the device from his grasp, but he refused to hand it over. This was not a planned display of anger. It appeared to be the reaction of someone feeling the pressure mounting and struggling to maintain composure as events unfolded in front of him. Then there is the matter of Melania Trump. When members of the president's staff contacted her office to request a public comment, perhaps invoking marital privilege or offering any form of assistance, they received no reply whatsoever. It was not an outright denial or an attempt to discuss options. It was complete quiet. In the context of a marriage, that level of silence often communicates far more than spoken statements ever could. This marks the third instance in her husband's various legal challenges where Melania has chosen not to be present or involved. On this occasion, her decision carries potential consequences that may significantly affect the outcome of the proceedings. Later, I will quote Warren Buffett directly on a related point because his observations go beyond any single political situation. He has spoken about the consequences when a leader sees every pillar of support withdraw from the legal system, from partners, from close personal ties, collapse due to eroded trust. But before reaching that, it is essential to examine the details of the judge's directive, the reasons the Marshals became involved, and the deeper significance of the First Lady's lack of response. If you find this analysis valuable, consider subscribing. This covers a president facing genuine isolation in ways we have not seen before. Begin with the substance of the court ruling, because its implications for the Constitution deserve careful attention. From the outset of this second term, the approach taken by the administration has followed a clear pattern. View judicial directives not as mandatory requirements, but as items open to discussion, postponement, or outright sidestepping. Over recent months, judges across federal districts have issued instructions concerning border policies, government spending, and the scope of presidential power. In many instances, those instructions have gone unheeded. In one key instance, Judge James Boasberg determined there was sufficient evidence of criminal contempt after concluding that the administration had shown intentional disregard for his directive to pause specific deportation operations. Aircraft carrying individuals were dispatched rapidly, preventing those people from contesting their removal through legal channels. The president of El Salvador shared images of the arrivals in restraints, and Secretary of State Marco Rubio amplified that content online even as the court's restriction remained active. The judge described the government's actions as deliberate and almost celebratory in their defiance. In another matter, Judge Paulinus directed officials to arrange the safe return of Kilmar Abrego Garcia, an individual the government acknowledged had been deported in error to a facility in El Salvador. The Supreme Court reinforced that instruction by requiring steps to enable his repatriation. Administration lawyers contended that facilitate carried no obligation to actually achieve the return. The recurring theme became obvious: receive a court mandate, then reinterpret it to render compliance unnecessary. Faced with repeated failures of other remedies, the judge resorted to the one remaining constitutional mechanism available, the United States Marshals Service. Federal law clearly states that the Marshals' core responsibility is to carry out all valid writs, processes, and directives issued by United States courts. That duty is not optional, it is required. When a judge instructs the Marshals to implement an order, it signals that every preliminary step, verbal cautions, formal documents, hearings on cause, findings of contempt, has already been attempted without success. The Marshals represent the final instrument available to the judiciary. The judge issuing this command did not seek a direct clash with the executive. No federal judge does. Lifetime appointments exist to shield them from political pressures, yet they function within a framework that relies on voluntary adherence to rulings. When an order is disregarded once, then openly challenged again, and contempt is met with public ridicule from high-ranking officials, a fundamental decision arises: uphold the rule of law or concede that it no longer binds this administration. This judge selected the path of enforcement. Legal historians point to few close comparisons in recent times. The most frequently cited example dates to the 19th century, when Andrew Jackson reportedly remarked about a Supreme Court decision that Chief Justice John Marshall had issued his ruling. Now let him try to enforce it. Though the exact phrasing remains debated, the attitude mirrors the current dynamic, one branch challenging another to follow through on its assertions. For more than 2 centuries, the United States has functioned under an implicit compact that the president respects judicial decisions, not out of physical compulsion since courts lack their own forces, but because the entire structure rests on mutual recognition that the law governs all. Once that consensus fractures, the result is no longer a routine disagreement. It becomes a serious challenge to the constitutional order. We have reached that point. The directive represents only one aspect. The practical reality of Marshals attempting to carry it out introduces another layer. The United States Marshals Service, founded in 1789 alongside the Constitution's ratification, stands as the nation's oldest federal law enforcement body. Its record includes pivotal roles in major legal milestones. Marshals accompanied Ruby Bridges to an integrated school in New Orleans in 1960 amid resistance from state leaders defying desegregation mandates. They implemented similar orders throughout the South when local officials blocked access to schools. Their purpose remained straightforward: ensure that federal court pronouncements become reality. They embody the tangible force behind judicial decisions. Yet a deeper tension exists. The Marshals fall under the Department of Justice, which answers to the Attorney General, who in turn answers to the President. Ordering the Marshals to compel compliance from the executive creates an inherent conflict. They must act against the authority that oversees their own department. This raises a question the framers in 1789 likely never anticipated. How does the system operate when the President directs the very agency charged with enforcing judicial mandates against him? No definitive answer exists because prior presidents have always complied. Scholars observe that if the Marshals decline to proceed or receive contrary instructions from above, judges retain other pathways. Federal procedures permit the appointment of alternative officers, state troopers, local sheriffs, or even private individuals, to execute orders. Such measures occurred during civil rights enforcement when federal authorities relied on state personnel or the National Guard. One academic likened the possibility to conditions more typical of earlier, less structured eras. Still, the legal basis and historical examples remain in place, meaning the judiciary has not exhausted its resources. Members of Congress anticipated aspects of this dilemma. Legislation known as the Marshals Act, proposed by some Democrats, would transfer oversight of the service from the executive to the judicial branch, placing it under the Chief Justice and the Judicial Conference. The measure has not advanced, leaving the system dependent on established practices. Marshals prioritizing court directives, and presidents refraining from directing law enforcement to disregard judges. Those practices assume participants value the underlying principles. In concrete terms, Marshals enforcing this order could involve delivering contempt notices to designated administration personnel, compelling adherence to prior rulings, securing withheld materials if necessary, and, in cases of continued resistance, taking individuals into custody. The focus would not fall directly on the president, as Marshals do not detain sitting presidents, but on subordinates acting on his behalf. Once those intermediaries face personal legal accountability, the buffer surrounding the chief executive diminishes rapidly. Picture a career official in the Department of Justice who carried out directives to ignore a judicial instruction. Suddenly, Marshals arrive at the workplace with paperwork naming that individual in a contempt action. Every federal employee now confronts the same choice: adhere to executive guidance or honor the court's command. Those directives no longer align. An additional troubling element deserves mention. The Marshals also bear responsibility for safeguarding federal judges. Reports of threats against the judiciary have risen sharply, nearly 400 investigated in early 2025 alone. Tactics include disturbing acts, such as sending unwanted deliveries referencing victims of past violence, like the tragic case involving the family of Judge Esther Salas. The president has repeatedly singled out judges by name, urged their removal, and used strong language to describe them as harmful to national values. Chief Justice Roberts responded publicly, emphasizing that an independent judiciary remains essential to balanced government. The same organization assigned to implement orders against the executive must simultaneously shield the judges issuing those orders from potential backlash. This combined role, upholding the law while protecting those who interpret it, faces unprecedented strain. Amid this institutional standoff, with Marshals positioned to act and the judiciary asserting its role, the president reacted in familiar fashion when faced with mounting difficulty. He lashed out publicly. Meanwhile, the individual nearest to him offered the same response seen in prior legal difficulties: complete quiet. The president's Truth Social posts followed his usual style but carried an intensified sense of urgency. Extended all-caps messages naming the judge, labeling the Marshals' involvement unconstitutional and disloyal, and accusing officials and prosecutors of orchestrating an effort to undermine him. Advisors and attorneys allegedly urged restraint, warning that each statement risked becoming evidence of further interference or defiance. Opposing legal teams captured screenshots almost immediately. Accounts from those in proximity to the White House painted a picture of significant disorder. Staff attempted rational discussion with someone beyond persuasion. Prepared statements were discarded in favor of impassioned outbursts. A leader long accustomed to projecting dominance now displayed clear signs of strain to a vast online audience. Trump has historically managed courtroom narratives effectively. During past proceedings, he addressed media outside sessions or used testimony to advance political messaging. Courts became platforms for performance rather than strict legal arenas. Marshals, however, operate differently. Enforcement actions cannot be reframed through statements or posts. A president accustomed to shaping perceptions now encounters an authority immune to dismissal or postponement. This marks a shift. Donald Trump confronting a situation he cannot redirect or escape, revealing the impact on someone unaccustomed to unanswerable limits. Melania's quiet carries its own distinct meaning. She has maintained distance from every courthouse appearance in her husband's cases. She was absent throughout the extended New York criminal trial in 2024 that resulted in convictions on multiple felony charges. Family members and in-laws attended at times. She did not. Defense counsel later attributed her absence to family priorities, such as their son's education. The pattern, however, persists across multiple matters. She has issued no public endorsements of his legal stances, appeared at no proceedings, and never formally asserted spousal protections on his behalf. When approached for even a basic expression of family solidarity, no answer came. This absence holds substantial legal weight. Federal spousal privilege shields private marital discussions from compelled disclosure. By choosing not to engage or formally claim that protection, Melania introduces uncertainty that could benefit investigative efforts. Legal doctrine distinguishes between actively asserting privilege to safeguard a spouse and simply remaining detached to protect one's own position. She has selected the latter, a choice with considerable ramifications in high-stakes litigation. Simultaneously, she pursues her own separate legal matters, including a defamation action tied to past allegations, with independent representation and strategy. As challenges mount for her husband, she maintains clear separation in counsel and approach. The juxtaposition defines much of the current moment, one side marked by visible, unrestrained public expression, the other by deliberate withdrawal and absence of commentary. In relationships, certain choices reveal underlying realities more clearly than declarations. When a partner facing profound legal peril receives no supportive presence or statement, only calculated distance, it signals a judgment that involvement carries greater risk than detachment. Power offers no immunity from isolation. The highest office can coexist with profound solitude in legal settings. Command of vast resources does not guarantee companionship when accountability arrives. At present, Donald Trump confronts an emptiness that online reach cannot address. Melania represents the nearest example of withdrawal, though hardly the only one. The broader tendency, associates, appointees, relatives stepping back, forms the most persistent thread in this account. Every layer of connection around him appears to be shrinking. Diplomatic ties, party loyalty, governmental structures, family bonds, and now the closest personal relationship. Internationally, long-standing partners have begun pursuing independent paths after perceived overreach in negotiations. Trade alignments shift to bypass U.S. dominance. Politically, key figures have resisted or departed over constitutional questions, with divisions growing as defiance continues. Institutions, including those shaped by his selections, have upheld limits on authority. Family members have provided sworn testimony confirming problematic actions, often met with criticism rather than protection. Business associates from decades past have faced incarceration. At the core, the marital bond, typically the most guarded, shows no alignment. No joint appearances, no shared legal front, no public solidarity. The person with deepest insight and strongest protective tool through privilege has opted for separation. Viewed as layers encircling the center, each has fractured or withdrawn. The result leaves the most influential individual globally standing amid widening emptiness, with judicial enforcement as the only active movement. Warren Buffett has long emphasized trust as the cornerstone of enduring success, whether in commerce, personal ties, or larger systems. Observing the current landscape with institutional defiance, fractured alliances, family disclosures, and spousal detachment, he would likely see confirmation of a fundamental truth. Relationships and structures built without trust eventually fail. Buffett has noted that establishing a strong reputation requires decades, yet destroying it can take mere moments. A moment's reflection on that reality changes behavior. The presidency inherited a 250-year legacy of respecting judicial authority, upheld consistently across administrations. That tradition now faces withdrawal. The Marshals Service carries 235 years of impartial enforcement. Any deviation under direction would erode that legacy swiftly. The marriage, spanning roughly 2 decades, sees its own standing tested through sustained non-engagement. He has also highlighted 3 traits in evaluating others: integrity, intelligence, and drive. Lacking the first, the remaining qualities can prove harmful. Surroundings filled with capable, energetic individuals become counterproductive, absent a foundation of honesty. Intelligence devises ways around rules. Energy fuels attacks on oversight. Without integrity at the core, the system undermines itself. The First Lady, partnered with evident capability and vigor, now navigates the fallout from absent foundational honesty. Another Buffett observation connects directly. Legitimate agreements cannot be forged with those who fail to honor them. The judiciary sought basic compliance. It was not granted. Allies attempted accommodations. Demands escalated. Family and associates offered loyalty. Reciprocity faltered. At the most personal level, the same conclusion emerged. Every entity engaging deeply with this president has arrived at the same realization. Only the central figure appears unaware. Buffett prioritizes reputation fiercely, forgiving financial losses far more readily than reputational damage. Here, control supersedes both. As control erodes through judicial action and personal withdrawal, few reserves remain beyond amplified expressions into growing quiet. That quiet, from the First Lady, from former partners, from institutions shifting to action, marks a presidency assuming its concluding shape. Historical presidents endured grave challenges, yet retained personal anchors. Nixon had his wife's presence at departure. Clinton benefited from sustained partnership. Even in earlier bitter conflicts, certain bonds endured. What distinguishes the present is the scope of withdrawal across every dimension: legal, political, familial, marital. No prior president has experienced such comprehensive detachment during crisis. The Marshals' involvement sets a lasting marker. Successful enforcement affirms judicial reach over executive action. Failure or obstruction suggests practical immunity, altering governance fundamentally. Either outcome reshapes the balance between law and authority. A legislative solution exists to separate the service structurally, but it awaits enactment. Until then, reliance falls on voluntary adherence to principles the current leadership has consistently disregarded. The First Lady's quiet serves as a powerful symbol. When the nearest relation determines defense poses greater hazard than distance, other bonds have already dissolved. She arrives last in the sequence, not first, after institutions, allies, and family have already shifted. A presidency encircled by enforcement officers and met with personal silence signals not merely difficulty, but conclusion. The issue is not if change occurs, but its form. Proceedings continue. Appeals challenge the order. Emergency requests seek delays. The judge stands prepared to name responsible parties for personal consequences. Higher courts may ultimately address core enforcement questions. Separate legal paths proceed for the First Lady unrelated to these matters. Currently, a contempt directive prompts Marshals' involvement due to non-compliance. The president's public reaction escaped containment by his advisors. His spouse, positioned to offer meaningful assistance through privilege or visibility, has provided none. Buffett's lifelong focus on trust as essential reveals itself here. No enduring entity, enterprise, administration, or union survives without it. Reputation built over centuries in institutions and decades in personal life now confronts rapid depletion through refusal to acknowledge legal bounds. Trump has always operated amid crowds, large gatherings, constant media, vast digital followings. External measures suggest constant company. Yet a deeper solitude exists, untouched by numbers. The solitude of facing judicial mandates without intermediaries, truth from close relations without filter, and absence from the one who could bridge most effectively. The most powerful office holder can stand utterly isolated. No crowd fills the void left by a judge's command, a son's disclosures, a wife's silence. From Mar-a-Lago and the First Lady's circle comes only quiet, a quiet signaling an era drawing to its close. Stay tuned. Future developments will clarify whether law applies universally or carves an exception for one individual, and his wife appears to have reached her own conclusion long ago.